This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael. Today we're diving into a fascinating topic. How can lawyers and engineers work better together? And what role does national culture play in shaping our industry? Joining us is Dr. Paul Tracey. Dr. Tracey is a dual qualified chartered quantity surveyor with a degree in law and 35 years of experience on international construction projects around the world. Paul teaches at both undergraduate and postgraduate level in construction law at the University of Salford and the University of Melbourne. He's been involved on complex disputes in building, manufacturing, nuclear, offshore and onshore oil and gas, renewable energy and utility projects. Paul's research focus is on the influence of national culture on time and money claims on international construction projects, and he completed his PhD on this topic. You'll hear how a difficult project in the Gaza Strip led to Paul asking questions about the impact of national culture on the resolution of disputes. Let's jump in. Paul, welcome to the show.
Thank you very much, Jennifer. Really nice to be with you.
Yes, lovely to have you here. So, Paul, you have had an extensive career in the construction industry, both working in private construction companies and also in academia. I wanted to ask you, what attracted you to study and work in the field of construction law?
I think it was a fascination with how things are put together. I could never, even as a child, walk past a construction site and not stop and look in awe at all of this machinery, this manpower and women power, and just seeing things come together. I'm a big believer in teamwork, and construction requires teamwork. So I think that's where the original fascination came from. And taking that on further, when I came, I studied sort of science A-levels, which would be our examinations you take just before you go to university. And I was a sort of physics, chemistry, biology background. And yet it didn't really appeal to me to follow a route in that career. But definitely construction was always the way I wanted to go, I think.
You've got a law degree, but you've also studied engineering as well. And you have described your role working in some of these construction industries as being a role that really bridges that gap between the lawyers and the engineers. Can you explain further what you mean by this?
Yeah, I think some of that, Jennifer, came from my training. So my undergraduate degree, my first undergraduate degree, was in quantity surveying. And I enjoyed most of the aspects of that degree. But I almost immediately took a real interest in construction law, so even an undergraduate degree. And like many people who pursue a career, they're very often inspired by a lecturer. And I had an excellent, unbelievable lecturer when I look back in Peter Hibbard in the UK. And the one thing I found there was that this ability to link, this what would generally appear to be a very dry subject with the reality of a construction project really fascinated me. I finished my undergraduate degree, I remember this in the June of 1988, and immediately enrolled on another undergraduate degree, part-time, in law. So I studied for an LLB, or jurisprudence degree. I was working at the same time, so it was 2 nights a week, but I was absolutely passionate about this amazing thing called construction law. And I always describe it to my students, whether that be in Australia, whether that be in Salford, in the UK, or wherever I am around the world, as I spent most of my career in this twilight zone where legal meets commercial reality. And I found it absolutely fascinating. So having sort of worked as a quantity surveyor for a number of years on site, I got the opportunity to make a move to the legal department of a large contractor. And I spent most of my time really acting as a bridge between the legal department and the commercial or engineering team out on site. And I really enjoyed that role. I don't think I was ever cut out to be a lawyer, But I really enjoy that fascinating but also very troublesome area where the law meets commercial reality. And throughout my career, from there I went to work for a large American organization, so you're right, engineering. I transitioned so many fascinating departments and met so many fascinating procurement specialists, project managers, the legal team, across all of these disciplines. And what I really found fascinating was, I guess, that fascination I had as a child with the ability of people to work together. And sometimes it's the positive tension that I think I enjoy the most. You know, anybody, I'm sure many of your listeners will relate to the fact that different departments within these large engineering organizations have different cultures. And bringing those together is a difficult task. But, I've seen project managers, project directors who've done that and just look at them in admiration and awe, because that ability to bring people together from different disciplines, from different national cultures, who've been trained differently, to bring them together with one objective is something that really speaks to me.
And so what are some of the practical steps then that you had to take to sort of be that conduit between the commercial teams and the lawyers?
I think the first thing that I acknowledged myself, and I think it was a useful thing for me to do, that I'm not a lawyer, but I have a great deal of respect for lawyers, particularly construction lawyers working in this challenging environment. So I think that was the first thing, to make sure that I didn't put myself as some sort of quasi-lawyer. I saw myself as a useful conduit between legal and commercial. And what we noticed in the legal department was that the same sort of issues kept arising again and again. And one of the things that the legal team were keen to do was to do some training to try and learn from our mistakes of the past. If we had a legal case that had brought out some very important lessons to be learned, to try and bring those through the business. I mean, the company I worked for was Bechtel, the large American organization, and it was good to work across these different departments. And one of the things I was tasked with was to go and do some training to improve not only commercial awareness, but these important legal principles that we had. As a business, we had a lot of procedures, a lot of legal procedures that needed to be complied with, and to emphasize in a manner that engineers, commercial managers, procurement, all these different departments could relate to. That, I think, was something that was useful, not only to the legal team, but also to the commercial team.
So do you think then that our formal education system prepares construction professionals for cross-disciplinary collaboration, or is there some work to do there?
The simple answer is we don't. And I'm really glad you asked that question, because it's something that I've learned, that we don't train our professionals as well as we could do. And my training, all of my background at undergraduate level, was about black letter law, and it was about measuring things, quantifying things. It was about using Excel spreadsheets, pivot tables, reading the contract, writing pointed letters, writing reports, presenting claims for time and money. And all of this was useful in that it paid the mortgage, but I don't think it was particularly helpful in terms of avoiding disputes. And that's something we need to do within the construction industry. There's this culture and acceptance almost that the construction industry is adversarial. And, there's many great writers and authors who've tried to challenge this problem that we have. Not least, if you go back to Sir Michael Latham in 1994, report about the UK construction industry. But I know that from my Australian colleagues, I know that they see many of the things in Australia that Latham was talking about, a lack of collaboration, a tribal nature within the construction industry. The way we train people in different disciplines leads to almost, when we ask them to collaborate, in many ways, it's counterintuitive. We're taught, we're very, very tribal. Quantity surveyors, and even when I talk about quantity surveyors, engineers, project managers, employers, clients, principals, subcontractors, we're very tribal. And the problem that we have there is that even within if I talk about quantity surveyors, we have contractors quantity surveyors and we have consultant quantity surveyors. They almost have a different set of values and beliefs. And I think that's problematic. And for me, the one lesson I've learned in this industry, Jennifer, is that we need to collaborate more, and that in many ways we have to look at the practices that we've adopted, the way we train our future professionals. Is it going to help the construction industry overcome these challenges that it's faced for so long. About Michael Latham, he wrote that report in 1994. He passed away sometime, good time later. But in 2004, he was asked, what do you think about that on the 10th anniversary of the publication of your report, constructing the team? I think that probably tells you everything about the themes that were in that report. What do you think about the progress that we've made? And he said, although some progress has been made, my big concern is that in 2024, predicting 20 years ahead, you'll need another report. And the sad fact is, Jennifer, I think we probably do need to do something differently again.
Definitely. So you've also in your career worked on many international projects. Can you briefly describe some of the different types of international projects that you've worked on?
Sure. I worked across a number of disciplines, and I guess that's another thing that appeals about construction. You know, it's such a broad industry, and you can transition across so many sectors. I've worked on power projects in the Middle East. I've worked on oil and gas projects offshore. I've worked on renewable energy projects in Latin America. I've worked on transport projects, manufacturing projects. I've also worked on utilities, and that's one wonderful thing about construction. It's such a broad industry, fascinating industry. But I think you probably know, Jennifer, wherever you go and you transition these sectors within the construction industry, do you know what? We come up with the same troublesome issues time and time again. So I've enjoyed all of that. And one of the most rewarding parts of my career was to be able to work internationally. And I've absolutely adored it. It's been a really fascinating part of my career, the one that I've really enjoyed, the ability to go and experience not only different cultures, national cultures, but also different approaches to solving some of these troublesome issues. You know, I've taught construction law in diverse places, you know, from Israel to Iran. And yet it's amazing when I've gone to these places that you would think will be very disparate and very different in their approaches. I've seen the same problems arise, and it's an acknowledgement amongst us that these stubborn, troublesome issues need to be addressed in a different way. So fascinating, from Sweden all the way down to Chile. I've absolutely adored that ability to work across different national cultures and, importantly, different legal jurisdictions and seeing different approaches. You know, from a common law perspective, to see how a common law lawyer might deal with an issue, to a codified legal system, seeing different approaches and thinking, we've got these troublesome issues that are common across this common law and codified legal system. If we were to give a common law lawyer a problem and give a codified civil code lawyer a problem, how would they address that problem? If I were a gambling person, I think I'd probably say the answer they come to may well be pretty similar, but the way they approach it is very different. So fascinating, those differences in cultures, national culture, but also in jurisdictions.
And so this involvement on these projects has led you to make some pretty important observations about the way in which national culture impacts on the resolution of disputes in construction projects, which in turn led to your research thesis. And that began with a real-world challenge on the Gaza power station project. Can you share what happened and how that experience sparked your interest in this issue of culture and claims management?
Definitely. I mean, the Gaza power project for me it formed and shaped my thinking about the construction industry in many ways. And it's a very difficult time at the moment and always has been, I think. But going back to the construction project, this was a contract that was supposed to be a 2-year contract for a power station, 140 megawatts. All of this is in the public domain. And yet it was a project that took 5 years to complete with major time and cost overruns, primarily because of the start of the Second Intifada, the civil insurrection, which required, I was acting for a Swedish contractor as a claims manager. But the project was particularly fascinating because it involved a number of different national cultures, whether it be the ultimate owner originally was American. We had a Lebanese project manager. We had an engineering team acting for the employer that was local from Palestine and also from Egypt and different parts of the Gulf. We had a Swedish contractor with subcontractors from all over the world. I remember a large Danish subcontractor. And the contract was under English law. There was a delay. There was a clear force majeure clause, which was defined, which was very helpful. The definition of force majeure was there. And it also entitled the contractor to additional time and money for events such as civil insurrection, war, etc., etc. And I was tasked with preparing the claim. And for me, it was an interesting form of contract. It was based upon a FIDIC form, but it was a bespoke form, an EPC, engineering, procurement, construction. So a design and construct or design and build type contract. And I went about that task following the training that I'd been given at undergraduate level and built up through my career with this set of values, this culture of here we have a dispute, we present a claim to the owner, we have a factual basis to that claim, and we have a time element to that claim, and we have a cost element to that claim. And we prepared the time, the delay analysis using Primavera P6 software or its predecessor in a logical manner using an accepted delay methodology that one might see in the Society of Construction Law protocol, etc. We prepared the legal argument in a manner that most lawyers would say was a logical approach. You might not agree with it all, but it was a logical approach. We interpreted the contract in a literal way because it was quite a clear contract. We prepared the cost, capturing the cost at the point in time the delay occurred. We supported this with detailed contemporaneous records from all sorts of places, including our accounts, including time delays, etc., etc. And it was a sort of claim, I think, that you and I, Jennifer, would say, well, you might not agree with it as an opposing lawyer, but you might say, okay, and I accept that it's been prepared in accordance with the contract and it reflects the contractor's position for additional time and money. And I would expect, or I expected, the claims or the commercial team on the other side to approach the claim and present the same challenges, and maybe causation, or don't like the methodology, or they don't believe, they might talk about concurrency of delays, etc. And yet that wasn't the approach. That they disagreed with the claim. And when we asked them, what part of the claim do you disagree with? They said, all of it. And this puzzled us and said, well, you can't disagree with it all. I mean, it says it's a force majeure, an event of force majeure. Do you disagree that it's an event of force majeure, this intifada? And it was very difficult to get to a position where you could actually make progress. And we would have numerous meetings. I mean, bearing in mind, it was a 4-year delay. So we presented a number of these claims. They came in great big boxes. We sent them around the world. And yet it was pretty obvious when you went to the meetings that they hadn't even read the claim. They weren't interested. They were just interested in coming to some sort of deal. And they were very grateful that the Swedish contractor had stuck with the project. I mean, the Swedish contractor stuck. They could have terminated after a year of delay. And yet the Swedish contractor, which might tell you something about the national culture or maybe the company culture, stuck with that project, no matter how difficult it was, and finished it. And eventually exports electricity. It still is. It's still the only, as far as I'm aware, the only power station in the occupied Palestinian territories. So an interesting project for me was this, where are we here? And I remember I sat in an office in London with all of these different national cultures, a lot of raised voices, a lot of frustration, I guess, probably on both sides.
Yeah, absolutely.
You know, looking out the window and thinking, what is happening in this room? What is going on here? Because my training hadn't prepared me for this troublesome issue. What is it that's preventing this claim from being progressed? They definitely wanted to pay us some money, but it was all done on a fairly, I would say, arbitrary basis. Some might say a capricious basis. You know, what's your reasoning for this offer against certain heads of claim? We would get paid for parts of the claim that we didn't think were particularly strong, and yet wouldn't get paid or an offer made for areas that we thought were concrete. You know, they were due to us, you know. So I got interested in and started for the first time, I think, Jennifer, thinking about, is this because if you come from a different national culture and you're a construction law practitioner or a commercial manager or an engineer, because of the way you come from, where you were born, where you were educated, you think differently about these sort of troublesome issues. So that's really where my interest lay. It was in a real life project, and it was like a little itch. It kept scratching at me. I went to work as an expert witness. I worked as a claims consultant and really enjoyed all of that. Working as an expert witness, again, this link between the legal team and the commercial reality, where they would be seeking my opinion on where do we stand in terms of costs or in terms of delays. So really fascinated by this area, But I couldn't stop thinking about this project. It never really left me. And I spoke with colleagues. It was interesting to hear them say, more experienced colleagues, and they said, oh, well, you see, the thing is, Paul, this is called national culture, and it's just impossible to get to the bottom of. So put it in the too difficult tray and get on with your role as an expert witness.
Right. Yeah, it's fascinating. It's something that you don't necessarily think about when you think about these sorts of issues that arise on these kind of projects and the impact that culture has to play. What are some of the most common issues that you've seen across these all sorts of different projects that play out when it comes to these differences in culture?
I mentioned earlier on about these troublesome issues, and it's a phrase I use to, particularly for my students, to try and get them ready for what they can expect in industry. Some of the similar issues, you'll know as a lawyer yourself, thinking about, letters of intent, change on construction projects, fascinated by the change. I spent most of my career really tracking change when I think about it, thinking about the problems with liquidated damages, thinking about the problems with design responsibility, prolongation. All of these areas I find absolutely fascinating topics because they're troublesome wherever you go. Unforeseen ground conditions, latent ground conditions, all of these issues where whenever you transition a jurisdiction, you'll almost certainly come across differences, but there'll also be a lot of commonality, even just transitioning political systems, geopolitical challenges that we face. But one of the most challenging things for somebody who goes to work internationally is to deal with this national cultural issue. And one of the big challenges, I think, Jennifer, one of the biggest mistakes, and one of the lessons I learned is I came to my research thinking that national culture influenced the outcome of time and money claims. That's what I wanted to explore anyway. And it's interesting because a little bit like my career where I spent black letter law, Excel spreadsheets, Primavera delay analyses, I was surprised also when I went and did my research into national culture. That involved interviewing 40 construction law professionals, engineers, project managers from 38 different national cultures, from Mongolia to Argentina, people from all different parts of the world, males, females, across a range of people, but all of them acknowledged that they felt that national culture was problematic on international construction projects. I think what we learned together, the research participants and myself, was actually underneath this complexity of national culture, there are perhaps some simpler things going on. And one of the challenges and one of the reasons I think why national culture proves to be an insurmountable challenge is because very often what we think is national culture actually isn't. And that's the big discovery for me, was that actually these things that I thought were national culture actually was something different. And that was corroborated across a lot of the research participants. And I saw this theory. I adopted a constructivist grounded theory for my research. I saw this theory crystallize and mature. And what I found was that the research participants were actually building this constructivist grounded theory on national culture with me. That, again, appeals to that sort of teamwork, collaboration. I really believe that that's the way forward. And yet much of my career was spent really in an adversarial situation.
So when you talk about these non-cultural factors that come into play, what are we talking about here?
You might look at a construction problem, an international construction problem, and very often, the number of times, particularly I think from more developed countries, Western, particularly maybe the UK, the US, I see it in Australia as well, that, you're working on a project that's got stakeholders from different national cultures. And you are sometimes puzzled by different approaches, notices for delay on WhatsApp, all sorts of different issues. But for example, if you were to work with a South Korean contractor, and this is the generalization, but sometimes I think stereotypes are generalizations, there's some truth in it. You might be surprised why a South Korean contractor doesn't understand the importance of giving notice within a certain timescale. Let's say it's a condition precedent under a contract clause for a time or money claim. It could be under the NEC4 form of contract. It could be under one of the FIDIC Yellow Book. These are clear condition precedents, no notice within a certain period or for a delay or for additional cost, then no legal entitlement. And although approaches vary, certainly under English law and most common law jurisdictions, the sanctity of a condition precedent clause is upheld by the courts. And yet, if you go to many civil code jurisdictions, that's not the case. If you were to go and work in Dubai and the UAE, the civil transaction code there says something different. If you were to go to South Korea, it's a codified legal system. And for them, there would also be some relief, possible relief, that a clause like that would not be applied literally or strictly. And yet you get comments from maybe a commercial team from the UK saying, these guys just don't get it. It's in the document, give notice within 28 days. But they do get it. It's just that they come to this project with a different set of values and beliefs. They come with a different legal way of thinking. And we must be aware of that, because if we're not aware of that, we might say this must just be the culture of South Korea. It's an easy trap to fall into, but it's also problematic. So some of these non-cultural, non-national culture issues, the basic output of my thesis, which you can get online from the University of Salford, it basically produced a model. And that model is an attempt to untangle the tangle of complexity that surrounds national culture. So what I would encourage people to do who are working on international construction projects, wherever they might be, whether it be in Australia, at home, working with stakeholders from different national cultures, is to have a perception lens of national culture and think about applying filters and asking yourself, really seriously, is this national culture? And what I developed was a series of filters that help take out the non-national culture complexity to enable you to apply established theories, such as Geert Hofstede, his theory of national culture and his 6 dimensions of national culture, to apply that, but only once you've taken out the issues that are not national culture. And this is one of the problems that I mentioned, that we have a situation where we come across something which is puzzling, like I did on the Gaza project. It's easy to assume that that is national culture, that is a cultural issue. But actually, the reason why you can't resolve national culture problems, perceived national culture problems, with the established models that exist, such as the 6-dimensional Hofstede model, is that it's not national culture that you're looking at. So I'd encourage you to take out those non-national culture issues, communication, jurisdiction, training, finance, esteem, the daily reality. If somebody's living in a potential war zone, for you to spend so much time talking about delay analyses and different methodologies and holding these up as being something precious, where somebody hasn't had electricity for 24 hours or 28 hours, that might well be problematic for them. That you're dealing with people whose daily reality is much different to your own. So think about those things and take a look at maybe thinking, is this really a national culture, or is there something simpler going on underneath this complexity?
I'm glad you mentioned Hofstede, but the 6 dimensions of national culture that spoken about in your thesis based on Hofstede's work, how would that apply or shape the Australian construction industry dynamics?
First of all, it's possible for you to do a comparative exercise. So if you were to be working, you are working in the Australian construction industry, if you're working with people from different national cultures, and maybe prior to the project starting, it's possible to compare Australia's national culture with up to 3 other different national cultures. You can do as many as you like, but it's the normal process that you would adopt is to use 3. And there's a portal, the Cultural Compass, or the Culture Compass, where it's possible for you to answer a number of questions, and for that model to produce, for you to choose 3 different national cultures that you'd like the Australian culture to be compared with. And it's possible to produce a report. It's like an intelligence briefing as to what you might expect working with a colleague from a different national culture, working with a superior from a different national culture, or managing a team from a different national culture. And it's interesting because this weekend, my students here in Melbourne who are studying global perspectives on construction law have done that very exercise. And this morning we actually had a tutorial where they said, wow, it was amazing. There were things I really recognised in there. I recognised about the colleagues I'd worked with. There were also challenges as well. I mean, Hofstede's 6 dimensions is not without critics, and quite rightly. It is problematic, this idea that there is. Geert Hofstede, he talks about national culture being the programming, the software of the mind. He said that he'd unlocked secrets of nations. Now, those are big claims. And unfortunately, Geert, he had a great life, fascinating character. Passed away in 2020. He was in his 90s. A fascinating character. And if you get an opportunity, there's a film that you could maybe take a look at. It's called An Engineer's Odyssey. Because Geert Hofstede, he actually transitioned so many industries. He started as an engineer with IBM, went on to become an anthropologist, went on to become a very, very esteemed. He's the leading light in the study of dimensional approach to national culture. So these dimensions, and from an Australian perspective, what is really fascinating, one of the students today was talking about how surprised they were. They compared Australia national culture with the United States. One of my students said to me this morning, I was surprised actually how much commonality there was. I expected there to be much greater differences. And again, it comes down to this sort of perception that these people are very different to us, Currently, if you look at the political climate around the world, it's challenging, to say the least. Some people might say, oh, wow, but I know some very thoughtful, sensitive, very insightful, intelligent people from the United States. And yet you could get this impression that, okay, they have a certain set of shared values and beliefs, but it's a disparate country. It's an enormous country. And Australia too, you think about Australia, you think about the cities, the great cities of Australia, but you go into the outback, you go into Queensland, Longreach, you go out into the world. It's a very different world out there. And that too has differences, not only in culture, in all sorts of different ways, but also the personalities are different. They face different challenges. So, I mean, for example, one of the dimensions, 6 dimensions. So these are the 6 dimensions. And remember, these are imaginary. So what Hofstede says is you don't actually, if you cut somebody in half, they don't have 6 dimensions written through them. But it's a way of measuring and comparing different national cultures. So he talks about power, distance, individualism, masculinity versus femininity, uncertainty avoidance, exactly, and long-term relationship, indulgence models, these 6 dimensions. But for example, one of the dimensions is uncertainty avoidance. So the extent to which, and these are obviously they don't apply to every individual, but there is a tendency for different national cultures to sit differently along the scale of these dimensions. So if we take a look at uncertainty avoidance, okay, that's the willingness to accept uncertainty. Now, one of the things, if you take a look, and it's stereotypical, and I've got a lot of German friends, and I've got a lot of South American friends, okay? I'm lucky like that, from a teaching, I get to know a lot of students from all different parts of the world, and we chat about this. But to go to a meeting in Dusseldorf, if the meeting's set at 10 a.m. in the morning, you arrive at 5 to 10, or you arrive on time, okay? And to arrive late, maybe 50 minutes late, is considered to be, well, not only inefficient, but also rude. Now, if you went to a meeting in Santiago in Chile, it wouldn't be unusual. And I know this is a generalization. Maybe you'll get some.
No, I know some Brazilian people, and I know there's talk of Brazilian Standard Time, or
Yeah. I mean, we have that in Donegal in Ireland where we live now, and we thought, you're on Donegal time now. So if a builder says he'll be there at 10, then it could be anywhere between 9 and 3. But but going back to that point, and I had a former student, now a friend, and she was telling me, they were working for a client, a European client, and they arranged a meeting time. And she said, we sort of left the office round about the time the meeting was due to start at the client's office. And we drove across Santiago, and the traffic wasn't great. So we walked into this meeting, and it was, Buenos Dias, and this guy was just not impressed. He said, well, what time do you call this? I said, well, what do you mean? He said, we said the meeting would start at 10. So, well, traffic was a bit bad. And, when we say 10, más o menos, and this idea of, even I was chatting with a friend of mine, I speak very poor Spanish, as you probably worked out. But we were talking about, now, ahora, like now. And she says to me, yeah, well, I said, and then this document didn't arrive for like 4 days. I said, I need it now. And this document didn't arrive. And she said, well, ahora doesn't mean now. I said, but that's the definition in the dictionary. It says, ahora is now. I went, no, not really, not in Chile anyway. It might be like that in Spain, but not in Chile, you know. I said, well, what should I have said, you know? Ahorita. Oh, no, don't say ahorita, because that means almost never, you're never going to see the document. I said, well, what do you say? He said, oh, al tiro, you know, al tiro? Yeah, at a shot. I was like, wow. And yeah, I was chatting with a Spanish friend who I was staying over at his place in Seville, and he said to me, should we go to the bar? And I said, yeah, great. He said, when do you want to go? And I said, al tiro. And he gave me this puzzled look. And then when we got to the bar, he said to me, what's this al tiro thing? And I said, well, that means immediately, doesn't it? No. I think it's a neighbourhood in Madrid, I think. Do you understand what I mean? And this is the same, you know, and, you know, one of the things about the UK and Australia, you know, we're two countries, you know, separated by a common language.
Wow, incredible. So do you think, if we're looking at overall and generalizations as we've just been talking about, do you think the Australian construction industry would be described as overall collaborative or more adversarial in the way that we approach things?
Well, I think we're making some progress. I know there's a lot of initiatives to change the culture of the Australian construction industry, and I applaud that and I try and support it. We talked about adversarial nature of the construction industry. You know, the construction industry doesn't have a monopoly on adversarial cultures, but it's gone on for too long. And I think we've got all the tools within our grasp to solve this problem. And I think we've got enough smart brains in the construction industry. And, you know, they're getting smarter. And I think the construction industry benefited greatly from more females. And I think that's one of the things I've really noticed, you know. And during my research, the most powerful insights came from the female construction lawyers. It was incredible to hear them, and I'm eternally grateful for their input, because I think it changed my way of thinking about a number of things. So that's been very, very useful. But we are too adversarial, and there are some initiatives to be more collaborative, and there's some great authors, not least some of them are teachers at the University of Melbourne or senior fellows who visit the University of Melbourne for their masters in construction law. But we can do better. And I think the way we can do that, Jennifer, is to train our future professionals differently. You know, I speak to my students here in Melbourne, and I speak to my students in Salford, and I say, look, you know, you're the future leaders of this industry. I'm still seeing the same problems that I saw 40 years ago. I don't want you to still be seeing the same problems 40 years hence. So let's change this culture. Let's work more collaboratively. And, you know, I taught you that transition, you know, from being a guy who reads black letter law, construction contracts, knew them from cover to cover, knew the clauses cover to cover, knew how to use them to our own commercial advantage sometimes, and to be almost obsessed with numbers, time. I mean, of course, that's important on the construction project, okay? But actually, I've not found them particularly useful. And what I have found, the most positive parts of my career, have been working collaboratively with people from different national cultures, different disciplines. And I've seen the power of working in a room with people from different national cultures. And the secret to this, you see, is that if you unlock this complexity of national culture, if you think about it differently and ask yourself, is this national culture or is there something else going on in the room? And once you've done that, and once you understand and you listen, you know, I'd encourage colleagues in the construction industry to really listen to people from different disciplines, different backgrounds. They've all got something to offer. And if we do that, then I think we can help change this culture of the Australian construction industry to make it more collaborative. And that's something I'd support.
Definitely. So to end our discussion today, what practical advice do you have for professionals working on projects to implement strategies to prevent disputes on these projects?
I think I mentioned that I've seen the same troublesome issues manifesting themselves on construction projects. I think it's time, really, and I believe that the catalyst for this should really be the owners, the principals, because I think they're in a position where they could help change the culture of the construction industry greatly. The problem is, if you think about culture, it's a shared set of values and beliefs. And there's many cultures, right? There's an industry culture, there's a company culture. Jennifer, you have a family culture, you know, if you think about it. And you were probably taught that by your mother and father and your partner's mother and father, etc., etc. You know, and you're sharing that set of values and beliefs with your children. So What I would say is, as a principle, we have an accepted culture of, I believe, very often lowest cost. And I know how problematic that is. I was listening to the Grenfell inquiry, and many of your listeners will be familiar with the Grenfell disaster. 72 people lost their lives in a fire in London. And the reports were issued, last year, September 24 was the second report. One of the most shocking things, I think, about that inquiry, and I listened to it during the pandemic, a lot of the evidence was given, some of it was given during the pandemic. And I was listening to the quantity surveyor, he was probably in his 30s. He was talking about there being a pricing error in the contract and the inability to be open and to try and get this resolved in a different way. And I'm not saying that, you shouldn't accept responsibility for your errors, but I could relate to that quantity surveyor. There are going to be criminal prosecutions, and I don't think it'll be against the quantity surveyor, but certainly the manufacturers. I think there's going to be some really serious questions to ask. What you could see there is almost pressure coming from the principal, from the owner, that there were cost issues, budget issues. And, you can transfer risk and you can transfer pressures, but one day it will crystallize, and it will crystallize in a manner that's going to lead to really unimaginable problems. And, and I don't excuse any of that happened, particularly with the manufacturers of the panels, of the cladding. But when I think about it, a different culture, we need to pay a fair price for the project. We need to move away from this lowest cost model. It's not working. It's leading to a situation where you get clients saying, that there is a claims culture in the construction industry. And much of that comes from that the margins in the construction industry are so woeful. If you compare them with other industries, I think our productivity needs to be looked at. And, and I believe contractors should look at themselves. I was a contractor's quantity surveyor. You can almost hear that, I guess. And some of your listeners will say, well, this is a contractor's quantity surveyor talking, or commercial manager. But I think for the interests of the industry, I think we need to work more collaboratively. I'm optimistic. I mean, we've talked about collaboration for a long time. I'm optimistic that this digital transformation that's coming will help us facilitate that. I think there needs to be greater transparency. And I think we need to move away from this idea of thinking that we can solve the problem just by the contract and commercial management. I think we've got to move away from that. I believe there's got to be an incentive. And I think we should incentivize good behaviour. So if contractors, we should get contractors involved earlier. We should get the whole supply chain involved earlier. We should work together, and there should be benefits, incentives for collaboration, and equally disincentives if people don't behave in a collaborative manner, or corporate entities don't behave in a collaborative manner. Because, the joy to be had of seeing a successful project that's actually built better, designed better, actually does achieve the outcomes that the principal, the client needs, is something that's very rewarding. And to walk past one project that you've been involved in, you hope it's still standing 25 years later, but to walk past it is a very special thing. And I think it comes back to that. I didn't even know what the word collaboration meant as a child, obviously, but thinking about it now, the one piece of advice I'd give the construction industry in Australia is this collaborative working is worthwhile. And I think we've all, as construction law professionals, commercial managers, clients, engineers, mechanical, electrical, subcontractors, the whole supply chain, I think we've got to make this industry better. We've got to change the culture, and we've got to work more collaboratively together.
All very common sense suggestions there. That's fantastic. Thank you so much for your time today, Paul. It was great chatting with you about your experience and your thesis, and just ending with that really practical, common sense advice. So thank you.
No problem at all. Well, no worries.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawana Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.